Welcome to this rebroadcast of Successfully Working with Special Masters for Maximum Results, hosted by the Academy of Court-Appointed Masters. I'm Tom Hagee with HB Litigation Conferences. The Academy of Court-Appointed Masters is an organization of experienced masters who serve in federal and state courts. They also have resources on their website, which you can access at the link below. Moderating our program today is Judge Richard A. Levy, retired from the D.C. Superior Court, where he was an associate judge for 15 years. He's also the past president and current board member of the Academy of Court-Appointed Masters. Judge Levy is now working with JAMS as a special master, mediator, arbitrator, and case evaluator. Joining him is Roger Haydock, professor of law with the William Mitchell College of Law. He is a nationally and internationally known special master. He has served as a special master and mediator in over 500 cases. He is founder and first president of the Academy of Court-Appointed Masters. Charles Bucky Zimmerman is partner with Zimmerman Reed. He's one of the two founding partners of the firm. He's a recognized leader in complex and class action litigation. Jonathan Redgrave is partner with Redgrave LLP. He has extensive experience in complex litigation. He has a specialty in electronic discovery, and he is editor-in-chief of the Sedona Principles. Paula Render is partner with Jones Day. She's an antitrust litigator defending clients in class actions and other cases against claims of price fixing, market allocation, and other antitrust claims. Paula started off the discussion answering the question, when should parties consider hiring a special master? She said that two situations came to mind, one in which the case is on an expedited schedule. She most recently worked with a special master as defense counsel to American Airlines in the Justice Department's challenge to American's merger with U.S. Airways. Paula said delay can cause mergers to crater, so they sought and obtained a very expedited schedule. Here is how Paula described the experience.
We had to do all of the discovery and all of the litigation that you would normally do in a few years. But merger cases, of course, only come along every once in a while. There are other cases where the schedule may require the use of a special master, a TRO perhaps, or a preliminary injunction hearing where the hearing really has to occur very quickly. The advantage of using a special master in a case with an expedited schedule is that the special master probably has a lot more time to devote to the case than the judge has, the district court judge or the trial court judge. And so the special master can meet with the parties on a daily basis if necessary to work out any kinds of discovery disputes so that the parties can keep things moving very quickly and meet that very, very fast schedule. Another time that I think we're all fairly familiar with the use of special masters would be in the e-discovery scenario. A lot of judges don't have time to wade through the e-discovery issues. They can be very time-consuming, and they can take a lot of technical knowledge as well. And so e-discovery can be a great place to use a special master. So I think any time that you need very quick access to a decision maker, when you need someone who can really spend a lot of time, I think that you will find that a special master can be a real asset. In the airlines case, our district court judge, Judge Kotar Katali in the District Court of D.C. had suggested a special master, and she in fact suggested Judge Levy, who's one of our panelists here today, and we met with Judge Levy on a weekly basis. We had calls with him more often than that, and it was really just an outstanding example of when a special master can really fill a need.
Are there, Paula or other panelists, to respond to comments Paula made, but also to add things? If you have a situation, and let's take the e-discovery situation, where you have a judge, a judicial officer, this could be a magistrate judge, who doesn't have the time, isn't inclined, doesn't have the expertise, doesn't have the interest to really get down in the weeds. Are there any diplomatic tips that panelists can share on how to broach the subject with the judge in terms of suggesting or creating an environment where a judge will want to appoint or agree to appoint a special master, particularly if both parties agree that that's needed?
Well, I would suggest, first of all, taking a look at the judge's schedule. If you find that the judge has some upcoming trials scheduled or something like that, then you could have a very graceful way to say, Judge, we know we're heading into some real discovery disputes. We're going to need a lot of time, and you've got this upcoming trial. So that would be, that would be one way to try and broach the subject.
Any other thoughts from panelists on that, or to lead into a related but I think important questions? When as Paula was outlining the factors that are on the slide, size, complexity of the case, a lot of anticipated disputes, time sensitivity, all are obvious signals for a special master. Are there some signals where, or some types of cases, other than the very small ones, which I think would be clearly not appropriate, where you don't need a special master and you probably don't want to ask for a special master, or perhaps even push back on the judicial officer who's suggesting a special master? Jonathan?
Yeah, Judge Levy, this is going off of a point that Paula made and the question you raised. I think there are times when you want one and times where you don't. And I say that not in the standpoint of a particular party wanting one, but when you think of it from the administration of justice, when will a special master actually help? So sometimes it's the complexity or size. Sometimes it's the particular nature of a question, so the ESI or the electronic discovery questions. It might be a case where you have a lot of information that's in structured data systems, and it's not something that you can just produce the data system, and it's not something where you're necessarily going to give access to the other side. So how are you actually going to negotiate and walk through that? That might be something where that particular data issue might be very complex, but the case itself maybe isn't as complex, but it might warrant having a special ESI master as opposed to perhaps one of these very large, like a merger case that involves a very tight timeline where you're going to go to trial within 4 months. So there's all sorts of different circumstances that roll into this. I think to the question you had asked just before, what can you do? Well, you approach the judge in the federal context in the Rule 16 conference with just a preview of what's going to be coming in terms of discovery, and that's the time when you can suggest that it's either due to the size and complexity of the case writ large, or perhaps certain issues, and I use the ESI example, but there are other non-e-discovery issues, such as if there's a particular challenge to privilege questions, right? And we know there's a lot of privilege information. There might be challenges as to whether an individual was acting in the business capacity or their legal capacity, or maybe there's crime fraud. Those are different issues. Again, the Rule 16 conference in the federal context, great opportunity to kind of preview that, and I think that gets judges thinking about whether or not the judicial resources can cover it in the time allotted, or if a special master makes sense, and then you can really judge whether or not that's the time to raise it.
Yeah, and presumably, if you came in with an issue-specific request for a special master, you could come back to the judicial officer later as the case went along, should a broader need for the same or a different special master come into play.
I think that's a very interesting point, Richard, because I think sometimes we think, oh, we'll appoint a special master for the whole case, or no, this case doesn't require a special master, as an additional judicial officer for the whole case. But sometimes it makes sense to just consider a very limited engagement. You have maybe a massive privilege fight, and so a special master can do an in-camera inspection of those documents without he or she will have a lot more time to do that, and then your judge isn't frustrated by the need to wade through a mountain of documents given his or her other obligations and commitments. So I think a limited engagement is another way to think about a special master.
Bucky, did you want to add something?
Yeah, thanks, Richard. I was going to say simply this, that in large MDL-type settings, I think we also have to be cognizant of the notion that there are magistrate judges in the districts that also get into the mix, and that we want to be careful that we understand between the judge and the magistrate judge where the different lines of authority with regard to disputes, discovery, privilege, ESI, or other matters that come up where the court and the other judicial officer, the magistrate judge, believe the lines of authority should run. I think before we get into specific special masters, we need to be cognizant of what the role of the magistrate judge will be, and that's especially true in MDL context.
You know, as litigators, we always knew one of the most important commandments was know your judge. And it sounds, Bucky, from what you're saying, that that applies here also in terms of know your judge, know the magistrate judge, ask local counsel if necessary, get a sense of what this judge's practice is in appointments or not, to get a sense when and if to approach the judge. And also what the judge delegates to his or her special magistrate judges, because some judges in some jurisdictions don't delegate a lot, and in other jurisdictions, in civil cases, they'll turn over everything pre-trial. So it sounds like it's important to know, you know, what the practice is with that judge in that district or that state or that circuit, as the case may be in state court. But let's shift, if we can, to the subject of the qualifications of a special master. You know, what are you looking for in terms of a special master? Bucky, you're a plaintiff's counsel. How do you approach deciding what you want, even before who you want, perhaps, in a special master?
Well, just continuing where I was going before, Judge, and I think knowing your judge and know your judge is the correct place to start. I like to be respectful to the setup that the court is comfortable with between the magistrate judge and the district court, obviously. And then with regard to qualifications and the next step of getting into special master appointment, I tend to look at them more as grouped, oriented into a certain group of issues, be it discovery or a certain type of discovery, or be it a settlement, not global settlement, but the negotiation of individual settlements within, say, a mass tort is a perfect job for a certain type of special master. And I think when you look at what the job is that you're asking the special master to take on with the permission of the judiciary, the most important thing for me, frankly, is availability of time and the desire to be committed to this particular piece of the puzzle, and then the type of fairness and impartiality that will be perceived by both sides. Someone who may be looking very favorably towards a plaintiff case may not have any qualification for someone who is on the defense side who wants a different type of special master. So it doesn't do me any good to be suggesting people who are very plaintiff-oriented, recognizing that it's going to have no credibility with the defense. So you have to have the intellectual experience and that impartiality and perception of impartiality that I think is most important. And then I also look at the costs. Quite frankly, I think it's always a factor, especially when you're dealing with an MDL where your costs are being well managed by the court, and trying to develop procedures that are actually going to simplify the litigation as opposed to making it more complicated. So I'm not as hung up in the appointment of special master qualifications with the specific intellect or even the experience so much as I am with the commitment, the willingness to get involved, and how they can make the case simpler for the litigants and have the respect of both sides.
Well, Paula, you're a defense counsel. In terms of what you look for, could you share with us your approach in terms of qualifications? And to pick up on something Bucky just said and ask you to reflect on this, when you're talking about merger cases, for instance, you're talking about a highly specialized area. Now, admittedly, when you draw your judge off the wheel, you have no idea if he or she is going to have that type of expertise. But when you're talking about a special master in a merger case or other type of technical case, perhaps a patent case would be another example. As defense counsel, is that one of the factors you take into account in assessing qualifications for a particular case?
I haven't looked at for qualification. I haven't looked at a special master and said, well, have they handled this exact kind of case before? That isn't usually my top qualification. I think my top qualification is this person universally well regarded, well respected, someone who both the plaintiffs and the defendants can agree on. I think if the person has complex litigation experience, and maybe I should modify what I said, I would certainly look for someone who's got complex litigation experience, whether they have merger experience or not, whether they have a lot of experience with multi-district litigation. I wouldn't be as put out by the absence of one or the other of those, as long as the person does have experience in navigating discovery in complex disputes. Because I think discovery is going to be the bulk of what the special master does. Now that said, if a special master has the specific experience with a merger case or with multi-district litigation, of course that's very helpful. But I think one of the keys is that the person has to be well regarded by both plaintiffs and defendants, and that narrows down the pool a lot in a lot of big complex cases, simply because a lot of special masters and mediators and other types of people who assist with litigation tend to come from one side or the other of the bar. And so when we can find someone who's got experience with complex litigation, who's accessible to both plaintiffs and defendants, I feel like we've gotten a pretty good choice right there.
Jonathan, you've been on both sides in terms of being a litigator in cases where there's a special master and serving as a special master yourself. In your approach in those cases where perhaps you're a consultant or working with a party, deciding about recommending to the party the hiring of a special master, or where you've been in cases picking a special master, what are your thoughts in terms of qualifications?
Well, in addition to the points made, and are very good with respect to kind of the respect that people would have for the individual in the legal community, as well as cutting out the extreme biases on one side of the aisle or the other. I've got 4 particular things I'd suggest. The first is looking for a temperament like a judge, and I mean that in the sense that you want someone that's an even-keeled, not prone to overexcitement, but someone who's engaged, what you'd want to see from a quasi-judicial officer. Second is someone who can foster what I'll call resolutions of disputes. So a special master will often call the balls and strikes in the discovery phase, for instance. But even in that phase where you're calling balls and strikes, and that's where your appointment order is, there are ways in which the special master can help the parties see that maybe they're not as far apart, and if there's going to be balls and strikes called, it's on a much narrower scope because they've agreed on the other parts of it. That saves time, that saves money, that's a good thing. So someone who has that kind of skill set. The third thing is someone who will actually make a decision. Having a special master just fills up time, fills up space with more considerations and thinking when you actually need a decision. That's not helpful. So you want to know that someone has a reputation that they'll actually make decisions. And the fourth thing, which may not be obvious to everyone, is you want someone that you believe is organized or has an organization around them that can make sure everything is organized. And I say that because I've seen instances where there's been a very highly qualified person, but they either didn't have the infrastructure or their innate ability to organize things, and that disorganization leads to slower decision-making, less prompt resolution, less prompt hearings, and that does not aid in the ease and speed of resolution. So organization is a thing that I don't think most people think of, but I think it's pretty critical.
This is Bucky. Let me add something on that, and I think those are extremely good points. And you talk about temperament and resolution orientation. forgetting about the notion that the case is going to get resolved, it's also important to recognize you want the special master to help you resolve issues, and not just the side issues, but help the parties resolve them or come up with ways to resolve them that don't always result in having the special master even make the decision. And to set that kind of platform where the master can talk and get parties to talk, and the special master can work with both sides to get them to resolve, is something that we tend to forget, to not focus on as much, because we're looking for calling of balls and strikes. And I think you raise an excellent point that temperament and the desire to see the parties or help the parties resolve their issues is critically important to me.
There was an earlier reference by Paula to the meetings that were held in the American Airlines merger case, and both there, and I think Jonathan experienced this in the tobacco litigation, there are times when a meeting with the special master at which the parties talk through issues and talk through anticipated motions coming down the pike can generate a sense of other ways to resolve the matter short of going through an extended motions process and taking it up to the judicial officer, even if it's a question of anticipating, the special master anticipating and sharing with the parties how the judicial officer might react to issues. Not exactly a mediation, but a discussion, perhaps as you would a judicial officer before filing a motion to compel, which is another way to make use of the special master. If I could, before we move on to the next topic, I'd actually like to swing back to the first topic in terms of do you need and when do you need a special master, because we got an audience question that is, how do you convince an unwilling party that the cost of a special master is a good investment?
Well,
Panelists, we can't plan on these questions, so go ahead.
Yeah, no, that's a great question. It really is, and it's one that comes up a lot. So sometimes I think people oppose the special master. They say they're opposing it because of cost, when in fact they simply believe that they'll get better decisions from the judge. Other times I think parties really are balking at the special master because they view it as unnecessary cost. We'll go through all this decision-making with the special master, and then we have to go to the judge anyway because whoever lost in the decision is going to want to appeal it by going to the judge. So I think that it's a really great question, and it definitely comes up. My experience has been that Judge Levy referred to the meetings that we had in the airlines case. My experience was that putting together a weekly agenda for that meeting was an opportunity for us to resolve a lot of issues before they ever spiraled out of control, before they ever blew up into big issues. And so it was money very, very well spent. It was money that saved us from parties digging their heels into particular issues and then refusing to budge. You know, we knew we had to come up with that agenda. We knew we had to walk it through with the special master before we could do anything. And so we tended to resolve a lot of issues before they ever became really contentious or really heated. So I think it's not going to happen every time. You're going to have some contentious issues, and Judge Levy did have to resolve some issues for us in the case. But I think overall, the fact that we didn't have to wait and kind of become more and more committed to our positions on different disputes and then take them to the judge and wait a couple more months for the judge to make a decision about those issues, I think that it absolutely saved us a lot of money. So that would be one example of one example of experience that showed that the special master was actually quite economical.
So, Judge Levy, I'd answer this by saying I think the question from the attendee is really reflecting the fact that those who manage litigation don't want it managed as if it was a good novel. They don't like surprises and they don't like mysteries. So a special master can often seem like that when it's an unbounded, oh, there's another person we're going to have in this, and we have to pay them. So how do you combat that? It's really going, and I think we'll talk about this later, but I want to just kind of say the answer probably lies in the scoping. What is this person going to be asked to do, and what are the expectations? And if you have a frank discussion among the parties about why we believe this is a valuable thing for us, this is the exact thing we're going to see this person do. He or she will do X and Y. And that's something that we can't accomplish because of either the burdens with the court, the accessibility of the court, whatever it is. You've got to make a particular kind of case about the value proposition for the special master there. And I think when you actually get granular into that kind of scope of the appointment and the expectations, that's when you get traction. But most people, if they're kind of like still in the unknown about it, and they don't have a kind of either a favorable experience from the past or they've never dealt with a special master before, I think it can just be daunting to say, I'm now going to have to write checks every month for someone to be doing what I think the court should be doing. So again, I think it's getting granular and working with the other side on the scoping. That is what I think is the best path to help bring another party to kind of a place where maybe you can agree on it.
And I would just add time is money, and if people and the litigants can be convinced that they can do things with less paper, in less periods of time, in shortened time frames, everybody saves time, and time is, in our business, is money, and so I think that's the real driver, that we can save a lot of time.
Yeah, I think I would just underscore that point, Bucky. I think that's a really good point. When you think about the cost of a motion to compel, and then you think about potentially being able to avoid that, and you just go in and sit down and talk with the special master, you probably pay for the special master every time you avoid a motion to compel. You've paid for him several times over.
I think we're touching on a number of subjects that will also come up later, and I think it's appropriate to touch on them here. And it sounds from the points Jonathan was making, which also tie into some future points, the scope of the special master's duty has to be outlined, at least in federal court, at the very beginning in the appointment order, the Rule 53 appointment order. And it sounds also like a possibility, and in a moment we're going to talk about the timing of the appointment, but for Rule 53 purposes, and apropos this question, dealing with opposing counsel, you can start and focus on a more narrow scope of duties with the knowledge that either by agreement of the parties with approval of the court or on the court's initiative, those duties can be expanded. It's real hard, if not impossible, to go back the other way, to constrict. A lot easier to expand going forward. But that Rule 53 order is on the front end. First document is going to have to outline the scope of duties, and that is probably a good place to focus on this. In terms of timing, Jonathan, you've touched on this already in some of your comments, and I was going to turn to you to lead on this topic. But if you would also work in the concept of, should the special master be one person, sort of a man or woman for all seasons, all issues, or, as you suggested earlier, you might have either a different person or only a limited use of the special master, at least on the front end. So what goes into your thinking when you're picking a special master?
Well, on the timing point, it's something that the rule doesn't really give you much direction other than, and I'm talking about Rule 53 under the Federal Rules of Civil Procedure, other than the parties have an opportunity to be heard before someone's appointed. And other than that, it's Katie bar the door. And I say that in the sense that it's not a bad thing. It really is an open field for the parties in a court to work together, and if there's a need for a special master, to figure out the right place for the special master, or special masters, the plural, and that's the second question you asked. But in terms of the timing, my experience has been that sometimes the parties will get in a protracted dispute, and then the court doesn't have time, and then the special master is called in, and you're digging out of a hole. They're kind of doing balls and strikes rather than some of the mediative, or I would call it more proactive engagement, where maybe you could have avoided the time and expense, as Bucky noted, of some of the motions practice. So what I'd suggest is that people look at the cases and look to see if they've got the complex issues of privilege or ESI or if it's a case that really needs substantial case management in a compressed time period where a special master could assist with that, then try to think of this and find a way to raise it or address it earlier rather than later, because that allows there to be a good, discussion at the front end before we get into the crucible of everyone kind of fighting over particular things, and we've laid the good groundwork. A specific experience I'm thinking of was where I came in and dealt with search terms, but they were already so far down the road, it was really impossible to think of it outside of the box that they were in to maybe have found a better way to go. And the case went on, and everyone did fine, but in retrospect, I wish I would have been called in earlier in that particular instance. So my advice on the timing is nothing's dictating it except for the reality that if you're going to get the most bang for the buck, having a little bit of front time and having that person in earlier when you know when you're going to need a special master, that's going to be better off for you.
There's that old elephant in the room which we always go back to, which is you don't want to be the first to blink when you're talking about special masters or discussing topics of resolution of any way, in any way. Frankly, I think that's very old school thinking, and I try very hard to never be restricted by that kind of thinking. I think early and often the suggestion of ways to streamline, and I believe special masters have a particularly wonderful function in helping us streamline, is almost always today the way to go. To think that there's a weakness by suggesting ways to be more economical and more timely, to think that that's somehow blinking is really old school thinking. So I would encourage everyone to think out of the box when it comes to that, and to not be afraid to find ways to get to quicker decisions and quicker resolutions or resolution processes for issues or ultimate resolution of the case sooner rather than later.
And Bucky, I think that's a great point, and we tie it back to Rule 26. You're supposed to be having a conference about where the case is going. There's obviously a number of triggers there, including things like privilege you're supposed to be discussing, or things to deal with the preservation, how discovery is going to unfold. It's a perfect opportunity to raise it in a non-blinking type of world, because you've got a number of courts, certainly the Western District of Pennsylvania, for example, that really advocated the use of special masters in a multitude of cases. Everyone up there understands that. But there are a number of other local rules dealing with ESI issues that have kind of raised this awareness of the potential use of adjuncts to help the system. So I don't think there's any, stigma attached to someone raising it. In fact, it's becoming more commonplace. I'm finding that the parties are at least discussing it informally as part of the Rule 26 conferences before you get to the Rule 16, or courts, quite frankly, raising it informally or during a Rule 16 conference, just as a point to touch on in the bigger cases, the MDLs, the large cases that are going to be there for the long haul. So what I'm seeing is it's coming up more as a discussion point.
And I would add to that, that in the Rule 16 orders and the PTO ones that I see now in organization of cases beyond appointment of lead counsel, but in the first pretrial conference, it's almost always on the court's agenda. Something about, do we need a special master, or when will we need a special master, or how can we approach the subject, or when can we approach the subject. So the courts are cognizant of it as well, and they're putting it out there right in the first PTO agenda.
We've been talking so far about special masters fulfilling an adjudicative role where they are decision makers. Clearly, you can have a special master appointed for settlement purposes, for allocation purposes, as a technical advisor. You can put the title on lots of different roles. But staying here for a moment where we're talking about special masters having adjudicative functions in connection with case management, discovery, ESI, can you have the same special master? Are there ethical implications involving the use of an adjudicative special master talking settlement beyond just saying to the parties, I'm going to adjudicate your disputes, I think you ought to talk settlement. Now go away and find someone else or do it among yourselves. But can one person play both roles? Should one person play both roles? And what are the ethical constraints and limitations there?
Judge, this is Jonathan. I'll kind of jump in for a second here and just going to say that without touching the third rail of ethics in some sense, practically, I think the experience people have had with magistrate judges who have done certain roles, they've been brought in to be a settlement facilitator, then they're not touching the rest of the case. I mean, there's a practical element here of people, if they, if they're brought in for that particular role and they're really trying to help resolve the entirety of it, getting them also simultaneously doing the other parts of the negotiations of discovery disputes or resolution of discovery disputes, it sort of distracts from the ultimate mission, and then that is starting to run against, it's going crosswise against the whole purpose of a special master that's going to be really doing a cost-effective facilitation here to help ultimately reach the Rule 1 goal of the matter and getting it resolved fairly and expeditiously.
Yes, let me put another spin on that, if I could. I have no difficulty when I have special master appointments in, say, a claims resolution context to have the special master determining who has what claim or how much a claim is worth, and also having that special master adjudicate, say, a statute of limitations issue or a qualification issue. So I think that special masters can serve the dual function in a claimant sort of a context. It's a little more difficult to do it in the adversarial function of the merits of the litigation, and then have that same special master play a role in the actual resolution of the case in a negotiated context. I have a little more difficulty with that. Not so much ethically, it's just so much can be said about the case on the merits that tends to sway one's view that makes it more difficult to be really neutral when it comes to resolution. But I think it's kind of a jealous sort of balance.
Yeah, I would agree with that. I think it's very dependent on the particular circumstances of a case. You could envision a case where perhaps one party has taken positions that the special master perceives to be just not very reasonable throughout discovery. Does that then affect the way the special master views the shuttle diplomacy that he needs to engage in to get the parties to get to a settlement? Does he carry over the same feeling that the party hasn't been reasonable throughout discovery? Are they still being unreasonable? I mean, even if they've been completely unreasonable during discovery, they're still entitled to whatever settlement position they have, and they may very well, at the end of the day, be the party who deserves to win the case. I mean, you just don't know, but there can be a real advantage, I think, to the parties in starting over with someone else. But I don't think that there's an ethical bar that would say if you've assisted the parties and you've really facilitated a great dialogue among the parties, now suddenly you have to stop and let somebody else come in and continue that dialogue because the subject is settlement. I think it's just very case dependent.
Perhaps one distinction that can be drawn in terms of the special master acting or touching on resolution is the avoidance of ex parte communications, so that all discussions on resolutions are done with everyone, because as soon as, and Paula, you touched on this, as soon as you start having separate ex parte communications on trying to resolve issues, you, among other things, raise the risk of, to use something that Bucky said earlier, not just the special master being fair and impartial, but the perception of fairness and impartiality, so that, as you noted, Paula, there's not a perception that the special master later making adjudicative rulings is basing it on something he or she learned or a perception they had as to conduct resulting from ex parte communications, which would be very different from everyone sitting around the table, both sides of the case, and the special master talking about issues with no ex parte communications and suggesting ways to resolve them short of litigation. In terms of next steps, how do you find a special master, which is our next topic? And Paula,
yes, there are several ways to find a special master. So I mentioned earlier that our judge in the District of D.C. suggested Judge Levy as a special master for the airlines merger case, and we were very happy to work with Judge Levy. That was easy. And I think that that is a particularly important criteria or a particularly important way of finding a judge. If a judge recommends a particular special master to you, then you know that judge has confidence in that special master. You probably are not going to face the scenario where the judge just redoes every single decision that the special master makes. So I think that that can be very important. I think often the parties will have experience with special masters that they've used in the past, and so the parties often, it's sometimes when we come up with a list of special masters, we find that our short list and the plaintiff's short list contain an awful lot of the same people. So the parties can often come up with a list themselves. A number of the courts have their own panels of special masters. So I think it was Jonathan who mentioned the Western District of Pennsylvania has a panel of special masters for e-discovery. The District of Delaware also has a panel of special masters. And so one of the things to do is to check and see if your court has a panel of specially approved special masters. That may be very useful to you. I would certainly suggest that people can go to ACAM, who Judge Levy and Roger both are affiliated with. They have a database and can provide special masters on with experience in particular areas and that sort of thing. So I think those are kind of the obvious sources for finding a special master.
This is Bucky. I would say this, and this is maybe a little trade secret I'm going to give away, is that I always try to ask my opposition for some names that they would suggest, and then hopefully I'll find one or more within that list that I would be comfortable with. I think that in order to have really good communication with your special master and confidence between the parties, somebody has to be comfortable and confident in that special master appointment and or designation. And if I can find someone that my opposition is comfortable with, that I'm comfortable with, I think we've gone a long way. Whereas if we go to anonymous, decisions from lists of people we know nothing about, but just come highly recommended because they're well accredited, I find that for me, can become more troublesome.
But let me ask, I like Jonathan's expression of a third rail, another third rail question in terms of the world of diplomacy. Have any of you experienced, without naming names, situations where a judicial officer has said to parties, I want to appoint a special master, and I'm suggesting John Doe, Jane Roe, P.S. this person is a former law partner of mine, or perhaps that person doesn't have any substantive experience, or you have questions about their qualifications. How do you handle that, if any of you have encountered that, or perhaps mercifully none of you have had that situation?
Well, Judge, this is Jonathan. There are a number of times where that has come up, and you have to take stock of how extensive the master's responsibilities are going to be in that matter to determine if it's something where you're going to have to raise the issue. Oftentimes I've found this is something where both sides of the have had the same concern. And there is a matter of working together, because it's not in the interest of either plaintiffs or defendants in some of the larger cases, the MDL cases, to have someone that a judge is comfortable with but is going to be unsuited for the task. And ultimately, that's not going to serve the judge well either. So it's a matter of working together as a team, plaintiffs and defense counsel, to kind of approach the court with an understanding of what the court had in mind with respect to that role, and an understanding of what the requirements would be based upon the lawyer's experience in similar cases in other jurisdictions, to hopefully be able to present a case for including other candidates, because certainly Rule 53 does allow on the federal side the parties to be heard with respect to the appointment. And again, you don't want to approach it with brute force. I have seen it where a party didn't want a special master and actually opposed it. But I've seen, you know, parties prevail on getting masters imposed over objections. It's kind of rare. But, you know, once you get into the adversarial point with the judge, everyone's biting their teeth, biting their gum, because it's really something you don't want to get to. And so I think this is something that takes good lawyering, and good lawyering isn't always about motion practice or filing objections. It's about working with your team, if it's a joint defense team or a joint prosecution, you know, a whole bunch of people on the committee, and then the other side to find a way to gracefully raise the issue.
And I would add that I think it can be an uncomfortable situation where a judge has someone in mind that he or she is close to. But frankly, it never troubles me at the end of the day. I don't think we're perfect. I don't think special masters are perfect. I don't think lawyers are perfect. And I don't think perfection should be the enemy of the good when it comes to the appointment of a special master. I think they can serve such an overarching positive function that I wouldn't let the idea that it was a former person associated with my judge as a law partner or as a clerk or as a friend in any way get in the way of it being somebody that I have to ask the question, can they help the case? And one of the ways I've worked through this in the past as well is oftentimes we maybe ask for a dual special masters. And so that if you feel like there should be a second opinion brought in or a second dividing of the engagement, you can sort of level it a little bit by asking for the appointment of a second special master. We did that in one of the large MDLs that I was involved in, and it really took any of the concerns away almost immediately.
On the screen, which unfortunately I just lost on my computer, we have the subject of interviewing candidates, always being a joint interview with both sides represented, but discussions about some of the topics that are truly fair game for asking special masters about them in the context of the discussion of the selection and finding the right special master. Do any of you have any experiences in that regard that would be helpful for our audience to hear?
Yeah, I have a few things that I think might be helpful. Certainly, I think that the parties do want to put together a joint statement of the case for the special masters, just to give the special master an idea of what's going on in the case, and you know, that will be sort of an interesting experiment. The special master candidate will know from the get-go whether the parties are at least able to achieve that much, a joint statement of the case or not. So I think that can be helpful to the special master from a couple of perspectives. You certainly want to know about the special master's experience, so that you need to know exactly whatever your particular issues are, whether you're looking for e-discovery experience or you're looking for experience in managing a very tight schedule. You want to know about that. But I think one of the really important aspects is something that I believe Roger may have touched on earlier, which is what about the infrastructure? What about the special master's team? Because in a complex case, a special master probably maybe there are special masters out there who can wing it and who can act completely solo, and my hat's off to them. I think that could be very difficult. It could be very difficult to sit in meetings with the parties and take adequate notes of exactly who said what. There's going to be some researching and so forth. So the special master needs a clerk and needs some infrastructure, and the parties certainly have the right and really the obligation to their clients to find out what the strength of those resources is. So those are certainly questions that I would want to ask.
And I take it, Paula, you would also want to be able to vet the qualifications of the law clerk, or not?
I'd want to know something about them. I mean, I guess when we go into court, we don't have the opportunity to vet the law clerk's qualifications, although I guess if we could, we would. So I'd like to know something about the law clerk's qualifications, however much we can know. But probably the main thing to know is that they do indeed, that the special master does indeed have a clerk or someone who can help the special master turn out opinions very quickly.
Let's talk about mechanics in terms of the mechanics of appointment, which would be our next topic. Jonathan, we talked a little about Rule 53, and indeed you led into it when you were talking about scope of appointment.
Yeah, so everyone knows, I mean, Rule 53 is your operative rule in the federal system, and you've got state analogs, but particularly under C3B2, for all the little subparts that you want to follow, you get into the content of what the order appointing a master must include. In that is very specifically about the master's duties. This is the whole scoping. We should spell it out. Some orders of appointment have been very broad, and if everyone's okay with that and the judge is okay with that, it can work. But for those situations where you really want to conscribe it, or if you got multiple masters, really make sure everyone knows their lane, their swim lane that they're supposed to be in. The mechanics will also include how the court and the parties and the special master want to handle the ex parte communications. Is that going to be allowed? And this can be, not only communications with the parties, but are you expecting that there's going to be any communications on the subject matter with the court and the special master? Whether it's going to be scheduling and kind of updates, or is it a situation where there's going to be more allowed for whatever reason? So it's kind of open on that, but you should really be spelling it out. Don't leave it to the mystery novel again. The nature of materials that are going to be preserved and filed as a record of the master's activities. I mean, it's not insignificant, but what sort of record are you creating? What's going to be required? All the procedures with respect to the time limits, how you're going to file stuff in front of the special master. The standard review is really out there in the rule, but of course the parties could choose to alter that. If you are going to choose and have a different standard of review, you have to put that into the appointing order. So those are the kind of things that you want to make sure you have in there mechanically. But even before you get to that order of appointment, this is kind of very important, is to make sure that the order can only issue after the master has filed that affidavit disclosing the grounds for disqualification. And it's very particular to the U.S. statute. It's 28 U.S.C. 455 that talks about judicial officer qualifications and where an officer must step back. So I've seen far too many instances where someone's kind of been put up for the special master job. Everyone's kind of agreed. They got even to the court, and it turns out they actually don't qualify because someone didn't do the right vetting with respect to 28 U.S.C. 455, and someone has to file an objection, or the master sheepishly, or the proposed master sheepishly has to slink back from the proposed appointment. So it's very important to make sure that homework is done in front when we're talking about these kind of mechanics. So I think these are just kind of, things that the parties have to think about. Oftentimes there's going to be a lot of consultation, again, between the plaintiffs and the defense in the bigger cases. Sometimes you're just going to be exchanging, competing drafts about what you want it to be. But ultimately, in most of these cases, I've seen the parties really agree upon what these provisions are going to be. So I know that rule. There are articles that kind of describe the rule in a little bit more detail, and I think people should, if you're going to get in a situation with a special master, make sure you don't ignore these mechanics of appointment, because they can delay your appointment. They can get you into trouble with that person being put up that's not qualified, technically, from a disqualification standpoint. And if you don't think forward to some of these other provisions about the mechanics, you can end up with a bad record. You can't find the record, or there won't be clarity about simple things like when you're filing stuff, how you're filing in front of the special master. So think about the details, put them down, take the time to work with the special master ideally so everyone's in agreement here, and then you can just get an order entered that's the rules of the road, and that's what you want from the mechanics.
What about when the parties have essentially agreed on a special master to be presented to the court? Is there a benefit or a downside to getting the input and views of the proposed special master candidate on the items to be placed in the appointment order, to talk those through with the special master before presenting it, or proposed special master before presenting it to the court? Ups, downs?
I've seen it both ways, but I quite frankly think it's usually better, because you're asking this person to, be the third actor in a three-actor stage presentation, and if you show them the lines before you throw them out on stage, they usually do better. So they can actually help correct some of the lines if it's not going to make sense coming out of their mouth. So I think, if I had my druthers, that candidate, if they passed all the other tests here, and we know we're kind of walking down that road, having them have a say in that appointment order can help leverage their experience as well as avoid unintended pitfalls in the appointment order.
Bucky, did you start to say something?
I would put an explanation. I would put an exclamation mark on that. I think that nobody knows the quality and the comfort zone of the special master more than the special master. I mean, if he or she is taking the appointment and the job seriously, they know their strengths and weaknesses, and they know what they need to succeed. And so I would be less constrained by what counsel want to put in, and more in tune to what the special master wants the order to look like, and the rules of engagement, because it's only that special master that knows what they're going to need to succeed in the engagement. And so the subject of ex parte communication, I think, is a really good one. I think certain special masters are very uncomfortable with that, and they want it all to be with parties present. Others, just like judges, are very comfortable and are very appropriate in having ex parte conversations, because they know where the lines are, and they know how to get answers to questions that they need answered without, becoming, biased or too friendly or too chatty with one side. So I would say that I would like, if in a perfect world, for the special master to really help me very much with those rules of engagement, and rather than try and put my restrictions on it in a preconceived notion that I have, work with the special master to find out what he or she needs to succeed.
Thank you. Obviously, what we've been talking about overall has been working effectively with special masters and special master candidates, but the special master has been appointed. He or she is starting to work in terms of creating a case management order, and assuming that the special master has been, and I will say, lucky enough to get involved that early in the process. Comments in terms of pieces of requirements, procedural aspects, meet and confers, privilege procedures, those types of things that would be in the case management order. If the special master candidate is involved or has been appointed and is working, is there an advantage to he or she sharing a draft case management order with the parties after getting their input and before sending it to the judge?
Well, Judge Levy, from experience with me, that I would much prefer that a draft was shared with the parties so they can have their opportunity to say you got it wrong. And honestly, I've had experience with you and others where that's very well received and time extraordinarily well spent, so people aren't just objecting and trying to correct it in front of the judge when everyone could have just had a discussion about what made sense and what didn't. So I think there's a tremendous advantage in having that kind of be a collaborative work product. And if people still have to object after that, fine. But it's usually so targeted, it's much more effective and more efficient.
It's really the beginning of the whole process, too. The special master is going to get much more of a feel for how the parties communicate and resolve issues. The parties are going to get a feel for how the special master does. So I think when it's a collaboration, you're going to get to a schedule that makes a lot more sense for everybody. The parties ought not negotiate. They shouldn't come up with a CMO without running it past the special master either. They've got to know what his time is like. He's going to have ideas from other engagements that may very well help them. So it really needs to be a collaborative process.
One other advantage from the special master point of view in terms of sharing the draft CMO before sending it to the judge is not only, as Jonathan pointed out, the parties can tell the special master where he or she got it wrong, but from the special master perspective, you get the chance to correct any errors if you're convinced there are errors. Alternatively, or in addition, you're actually getting the arguments from the parties which you can then address in the next version of the CMO before it goes to the judge. So basically, it works both ways. The parties get to comment on what they view as problems with what's proposed by the special master. The special master gets to see what's bothering the parties and clean that up before sending it to the judge. Paula, you raised the issue, which happened in actually merger case, tobacco cases, of meetings, and the concept of meetings with the special master involves whether it's weekly, monthly, in person, sometimes by phone, but organized, regular, routinely scheduled meetings on everyone's calendar where the agenda has to come in from both sides a couple of days before, where the parties jointly raise issues and can separately raise issues, but no surprises at the meetings because everything's limited by the agenda except for emergencies. Advantages, disadvantages from the parties' point of view, really from counsel's point of view. I've only seen it from the special master angle, but what's it been like on the other side?
Well, nothing focuses the mind like a deadline. And so when you have that deadline, not a deadline where the motions to compel have to be submitted, but a deadline for teeing up the issue, getting to impasse, so forth, if that's the only result. I think having a standing meeting with the special master in a very large, complex case can really provide a way to keep things moving. You put the issue on, you talk to the other side about the agenda, you put the issue, you put it on the agenda, and then it becomes part of that conversation. The special master is going to expect to see some progress, and then every time you've got to update that agenda for your next meeting, if you haven't made any progress, you better make some real fast. So I think that can really help the parties work together more effectively and stay on top of issues and get them resolved. And as I said, in the airlines merger litigation, it really helped us resolve a lot of the issues before they ever got to Judge Levy's attention, where Judge Levy had to address them. We were already working out some kind of a solution. I think I remember there was one issue, and I don't remember the specifics of it, but one side was taking a fairly extreme position, and that they took that position throughout the discussions with the parties, but then when it came time to putting it on the agenda and having Judge Levy take a look at it, suddenly the extreme nature of that position got moderated quite a bit. And I think that that's another example of how that the regular meeting and the regular discussions with the parties can help make issues not ever become the contentious issues that they might otherwise.
And I might also add to that, I think Paul, that's absolutely correct, deadlines and agendas. But I also think it's also important to have a discussion of non-agenda items available to have, because A, things come up at the last minute, But B, it's also, you want to have a forum where discussion and dialogue can also be refereed, if you will, by a special master. I think it's a safer place when you have a three-party discussion to talk about things that maybe aren't on the agenda, but either need to be or are sitting out there to be on a future agenda. So I don't think we should just be completely constrained by the agenda as much as it should be our framework, but there should also be an open item, some open items that we can discuss, or non-agenda items that we should be able to discuss as well.
Yeah, Judge Levy, I'd say this is something that Magistrate Judge Facciolo in the District of Columbia has been a big advocate in his role as a magistrate judge when he's serving a lot of the same functions that a special master might, really getting the parties in civil litigation to have these regular conferences or even just telephone check-ins. Even if there's nothing to discuss, you just kind of say, okay, there's nothing to discuss, but forcing everyone to kind of be on this pace, kind of like an exercise regimen where you got to meet your mark. And I've heard some people that just don't like this as much, but generally I think what Paula reflected, and I think Bucky's experience is, whichever side you're on, you know, it tends to help things continue to move. The one thing I think Bucky that he raised about having an open forum for people just to be able to discuss where we are without necessarily having agenda items, that's something that kind of gets both sides, or at least certainly I think I've heard a lot of defense lawyers get really nervous because they think someone's going to come in and poison the well, or say you come up with this dramatic moment. And I got to tell you, I think a lot of times that's overblown, because I haven't seen that many instances where someone comes in with a Perry Mason moment, and you know, we kind of all like to think we're more dramatic than we are. The reality is, with a special master as opposed to the judicial officer, I think there can be a little bit more informal means to it, but I would certainly, if I were the special master, want the parties to have discussed with each other the kind of things that are going to come up, because they're really, if the system is working well, there shouldn't be anything to either side that's really a surprise at the meeting with a special master. And I would hope that there was at least some dialogue beforehand, and whether or not you set that into the operative case management principles or not, you know, certainly my expectation if I were a master would be that the parties had talked about it at least, so they can at least have a meaningful dialogue with me, not a monologue about what's about to happen. And I think if I'm a party, I want to have that, and I want to, if I'm across from Bucky, I want him to know before we're going to talk to the master, you know, whether or not it's on a formal agenda, I want him to know there's something that's coming up with respect to depositions in Europe or whatever the issue is. And I know he's going to be treating me the same way, letting me know there's something with respect to product testing or something where he's got a concern. So again, if we stop thinking about this completely, you know, I hate to say this, as fighting advocates with zealous, you know, pursuits, that part of discovery, especially on the civil side, is really finding a way, you know, to take this identical cooperation proclamation, some of these concepts of how do we make the system work better for our clients, whether they're individuals, whether they're large companies, or everything in between. How do we make the system work better? And I think the whole idea here of having this regular kind of conference is just a tool that allows the parties to have meaningful dialogue, to get rid of the stuff that we can agree on and fight about what matters.
Let me raise two other points quickly, and then actually Dennis.
Judge Levy, I'm sorry, may I interrupt? There is a speaker who or there's an audience member who submitted a question, and I think you may not be able to see the questions at this point. Is that, should we talk about the question, or can I tell you what it is, and you can decide whether we should talk about it now or later?
I think Tom has gotten them to me. I wanted to hold a little,
fine, then.
And then we'll swing back to him. I also want to get to Roger for picking up on some ethical issues we haven't covered. But two other things to think about in terms of working with special masters. An idea which attorneys in the AT&T T-Mobile merger case proposed, which I honestly never would have had the guts to recommend. They recommended word limits on motions, oppositions, and replies. 750 motion, 750 word opposition, 250 reply, including footnotes. It was amazing to see how efficient, not amazing, it was a pleasure to see how efficient counsel could write, with the understanding that there were certain classes of motions which would have higher page limits. And the other thing that counsel agreed to in several cases was the fact that the special master's ruling would be final except on a carved-out class of issues where the parties would otherwise appeal to the district judge. That can only be done by agreement of the parties under Rule 53, but it can be done. It can save time and money. I don't know if, I know Paula was involved in cases with those requirements. She has any comments, or either Bucky or Jonathan have?
I think one of the reasons that we were able to agree on those limitations was because we had such an expedited schedule. So with 4 months to do everything, there just wasn't time for lots of lengthy motions to compel and so on. I'd love to think I could agree to limitations that made sense in a case that was more of a typical pace, but I don't know. I mean, I might not be quite so willing to be limited in terms of the length of a motion to compel in a regular litigation, at least not that limited. But I think those limitations did help us focus and, again, helped us get straight to the point. Having the regular meetings meant that we knew we would be able to articulate anything that we didn't feel like had come across well enough in the motion. So it did work very well for us, and some kind of limit, although maybe not quite that drastic, I think would serve the parties very well with a special master.
Judge, this is Jonathan again. I would say that I don't mind borrowing from places that I think have procedures that work. In the Southern District of New York, having the pre-motion kind of letter practice, or actually substituting the letters for motion papers. You have to write whether it's no more than 5-page, 3-page, 2-page, 1-page, depending what the issue. I found it to be successful that, you force the parties to crystallize, and that's the issue. Okay, let's talk. It really helps, again, foster all the things that, Rule 53 is really tying into Rule 1 to make sure the process, is fair, but one that's not adding expenses, actually, kind of reducing the total expense. So there's a fairness in imposing the expense of a special master, and you can, in the process, create unreasonable expense or unreasonable delay. So short motions, or letter practice, I think the parties should think about that and realize they may have carve-outs, but for others, you can get by, and that's actually better for your client.
Okay, let me, if I can, shift over to Roger for some ethical comments and perspectives, and then if we have time and depending upon the questions, I'd like to swing back to a couple of other issues. Roger?
Well, thanks, Richard. An ethical issue that arises with masters relates to ex parte communications. We understand with settlement or mediating masters that ex parte communications with parties and lawyers are common and expected. But with decision-making masters, those who are making decisions on discovery or motions, what's the appropriate role, if any, of ex parte communications? And some masters distinguish between procedural and scheduling issues versus substantive and material issues. But so my question to the panelists is, what's your view on whether there should be broad or restrictive opportunities for adjudicative masters to have ex parte communications with lawyers or parties? Bucky, you want to go first?
Yeah, Roger, thanks. My view is that the reason we're having special masters in deciding these issues is for the reasons of better communication and better understanding and limiting the process somewhat. So I think we're all saying the same thing about that, whether it be pages or words. But with regard to ex parte communication, I think I'm not troubled by it at all when it's procedural. I'm not troubled at all, of course, when it's resolution. A little bit on the substantive stuff, but frankly, I think that the special masters that I've known are professional enough not to be swayed by ex parte communication as much to gain understanding. And to the extent that they gain understanding, I think we all benefit. And so I would not have a bar to limited and appropriate ex parte communication that a special master would want to engage in.
Paula, your view?
I think, again, it's very circumstance dependent. So I think the parties should think about this very carefully, of course, when they're putting together the appointment order. And there may be certain kinds of communications that they want to make ex parte communications. They may be willing to agree to those kinds of communications, and others where they're not willing to. So it's going to be very circumstance dependent. But generally speaking, I agree with Bucky. I mean, the whole point of having a special master is because you're looking for someone to help the judge and perhaps do some things that the judge might not ordinarily do. And so it's a good option to have and a good option to think about and to decide when is this a good option, when does it make sense. Certainly, I mean, the communication itself may be ex parte, but I think the parties always need to know that an ex parte communication has occurred, or that ex parte communications within a certain category can occur, but it's just something that you need to think about based on the circumstances of your case.
And Jonathan, what's been your experience both as a lawyer and as a special master regarding ex parte communications with parties and lawyers?
Well, my experience has been that it does happen more with a special master, and the parties are expecting it. I think where problems arise is when the parties have different expectations about when it's going to happen. So one side's just shocked that there's gambling in Casablanca, or that someone's talking to a special master. Well, the reality is people should understand there's going to be more of an opportunity for all the good reasons we just talked about. But again, if we go back to the best practices here, it shouldn't be an issue, because in the content of your appointment order, and this goes right back to the specific text of Rule 53, where it says the circumstances of any, this is the appointing order has to, address, must state the circumstances, comma, if any, comma, in which the master may communicate ex parte with the court or a party. Okay, that is not only your invitation, but that's your requirement under the federal system to state it. So if your state law analog does not have the same sort of mandate, again, it's a best practice for everyone to understand what the playing field is. And again, I think Bucky's point is very, very good. Most of the people that I know that have been doing this for a while, they've been appointed in a number of cases, they're very judicious. They're very well suited to understand, what the right rules of the road are and what to do with respect to the proper communications and avoiding improper communication. So again, I think there's a lot of just institutional value in people that know this, that have been either in the role of a judge or the special master before. But that said, don't forget to write your rules of the road. That's the way to best deal with this.
Have any of you had any experience with perhaps when there are no rules of the road, what you perceive as inappropriate communications between a decision-making master and the appointing judge in a case that has been bothersome or inappropriate from your perspective? Anyone?
I have not. In fact, I've had just the opposite, where I thought the feedback to the court was fair and was enlightening, and things that were happening in the special master's quarters, if you will, or the things that were happening offline from the court, when reported by the special master, advanced the case as opposed to detracted from the case. But sometimes it's what you don't know that hurts you, I guess. I have found the opposite, Roger, to be true, that the communication was good for the case, not bad for the case.
Okay.
I guess maybe a slight variant, Bucky, and I think this is probably some experience you've had as well, is that a special master will either tell the parties before or after an ex parte contact with one, or with an ex parte contact with a court, for example, but certainly even with another party, kind of at least not reveal the content of that, but there's a level of assurance given that, this is happening, why, and that helps not just the lawyers in the room, because remember, we've got people outside the room called the parties, and the parties get nervous about the thing called ex parte contact. They think they're getting, a raw deal or something that is not fair about the process, and oftentimes that extra communication from the master about the existence of a contact, or not revealing the full nature of it, but something about it that gives assurance to the process of fairness. Sometimes that cannot be understated, the value of that.
Paul, any final comment on that issue?
I think that the other panelists have said it pretty well. I guess if I thought that the special master was really not communicating appropriately to the court, I'd have to be looking at whether it made sense to continue participating in the special master process, or whether I wanted to petition the court for a change of special master or something like that.